Chicago, a jury consultant and lawyer. Alan, what's the impact on the jury watching her being questioned like this by detectives who are playing this good cop, bad cop game with her?
They get to evaluate her and actually she has to say. And there's probably some mixed reaction. Some people might look at this and the interrogation room. Now, it doesn't have the image of somebody being escorted out of a police car in handcuffs. She's a suspect, she's being interrogated. They might tend to infer guilt, while others look at her and think she's very calm, she's answering the question. Probably not somebody who loses her temper to do this. 3-year-old, probably a whole variety of evaluations taking.
We don't know how what happens here, but I guess the authorities are trying to force her into a confession, to box her in, essentially.
Interesting. And then that's a whole other area of inquiry in terms of forced confession. See how it plays out. And jurors come into this case with pretty much a blank slate of the case, but they have heard about forced confession, about interrogation, about law enforcement. A lot of how they evaluate this case is dependent on what they come in with, generalized views.
At one point, one of the detectives said to her, either the father killed her or you killed her. It's one or the other. I guess giving her the opportunity to point the finger at someone else. She didn't do that. As they pushed her this way, and they've told her now several times she has the right to have a lawyer, she has the right to remain silent, she continues to talk. From the point of view of the jury, does that suggest that there's an innocence?
I think the jury can appreciate that. Now, a lot of people, law degrees will say that's a no-no, but I think your everyday layperson will tend to equate willingness to talk about a lawyer and having nothing to hide. I think that does.
And in this case, and in the case, again, well, here comes the detective again, we're talking about the death of children, which has a particular impact, I assume, with the jury as they watch and try to analyze and, as you say, sort of assess for themselves, is she capable of killing a child?
Yeah, very emotional, and that's what this case is tinged with. During jury selection, the defense should have hammered home, and they probably did, the notion that, are you going to give my client a fair shake? Obviously, this is a terrible tragedy. And you have to not let emotion factor into your decision. You have to save beyond reasonable doubt that she did crimes. Yeah. And for some people, how fast? A lot of those people had jury.
We're back now with our coverage of the trial, the murder trial of Lindsay Parton, a 36-year-old woman in Butler County, Ohio, outside Cincinnati. She's charged with the murder of a 3-year-old girl for whom she was babysitting, Hannah Wesley. You're watching the interrogation tape. You're seeing exactly what the jury has been seeing for about the last 5 or 10 minutes. And for the most part, she's sitting by herself in this interrogation room. We're not sure why the jury is seeing all of this. Alan Tuerkheimer, you're on the line here. Why would they be showing her sitting by herself with no real audio?
Well, just to get a feel to see if she still seems composed, if she gets up and starts pacing, anything that gives jurors a read on what she's like during this time, helpful in ways maybe once reminded this time. I think of Jodi Arias when she was interrogated. She was singing, saying a lot of strange things. That's a whole nother story, but I think just it gives jurors a glimpse into her state of mind and how she's comporting herself during this interrogation.
That's a portion of the interrogation tape that was played earlier today. Live, the jury continues to look at a portion of the tape with Lindsay Parton just sitting in the interrogation room, nobody else there, just checking that. For whatever reason, I guess they're trying to show Alan Tuerkheimer that she's calm, she's not crying, she's not fretting. What do you make of her demeanor from what you saw in that earlier clip?
So from the first one I saw, I didn't just see this one. She did seem pretty calm. She seemed deliberate. She seemed like she wanted to do her best to answer the question. And if it's an act, then it's going to be hard to keep that going throughout the interrogation in a consistent manner. And that's what I think a lot of the jurors are going to be looking at, whether or not anything deviates significantly from how she handled herself at the beginning part of that interview.
And do you think she has continued that kind of demeanor during the court? She's been sitting very passively during the trial, watching but not really showing much emotion.
I think so. It sounded like, and it's from earlier, it seemed like her tone was a little more emphatic in some of those questions that were made. But overall, it sounds like she's doing a good job of portraying a consistent demeanor and general disposition.
What do lawyers tell their clients about how they should appear in front of the jury? What they should show? Should they show emotion? Should they show a stony face? What's the best advice for a defendant in a situation like this?
I think the best advice is to say, first of all, be yourself. Anything that's not genuine is going to be interpreted as a concoction and something that is artificial. But I think it's also important to let defendants know that there's such a thing as rightful indignation, where if you hear something or somebody says something that accuses you of something that is absolutely not true, then you can't just passively accept it to try to maintain your demeanor. You can object to it, or you can show that you have a pulse that are not just going to accept every question away. So a little bit of emotion, courage.
And that's how she's been looking throughout the trial. Again, what we're seeing on the screen now is what the jury is seeing at this moment. It's been about 10 or 15 minutes in which the interrogation room is, their detectives have left. She's sitting there by herself. She's not really doing much. She's stretched a little bit. Alan, let me show you an earlier clip that we have where she's also questioned by the detectives about what she knows. So that was her in a tape played earlier today for the jury. Alan Tuerkheimer of Chicago, let me ask you, she's told a version of events. Does she now have to take the stand and repeat that version, you think, for the jury to be satisfied?
If she's really telling the truth, certainly the jurors are going to want to hear from her. But if she does take the stand, she most certainly has to be consistent with everything that just unfolded that she just talked about. So there's certain pressures that she's going to face. But this is a record now, and jurors are not only evaluating her from the standpoint of what would I have done if I was in a situation, but also a picture starting to emerge, and does it affect testimony so far? And at the end of the day, it has to be what she testifies to. She does.
And almost never do defendants in a case like this take the stand. The cross-examination can be brutal. It can defeat the whole purpose of it, I take it.
That's true. And during voir dire, the defense should have inoculated against that, or at least spend time making sure that every single juror that sits on this jury will listen to the judge's instruction and not make any negative inferences about the defendant should she choose not to take the stand. Like you alluded to, cross would be pretty brutal.
Well, again, the video we see on the screen is precisely what the jury is seeing in this trial in the courtroom in Butler County, Ohio, as we continue to look at Lindsay Parton as she awaits the detectives who are outside the room. Alan, this is always a fascinating part of watching any trial, to see how the process works. And it's not Columbo, it's not Perry Mason. It takes a while, and the police obviously have a strategy here. What do you think they're trying to achieve?
Well, they're trying to paint a broad picture of what's been going on. They want to maybe try to catch her, trip her up in an inconsistent statement, or maybe some kind of fashion. But I think overall, they're just trying to show her that, for the jury, that this is somebody who's taken care of this child for a long time, and while she might be able to relax and show that she's a top-notch caregiver, she has a tendency to trust her. Pretty big child, and right in front of you, sitting here during this questioning.
It's fair to say, isn't it, Alan, that if she had a lawyer, this would not be continuing like this?
That is true. If there was a lawyer, this would not go on and on the way it is, right. Which might for her benefit on some level, as we talked about earlier. Some people might think to themselves, look, if I was innocent and I had nothing to hide, I would cut both ways. But certainly if there was a lawyer involved, we wouldn't be seeing this.
Well, again, you are seeing, our viewers at home, what the jury is seeing in the courtroom in Butler County, Ohio, and that is a long interrogation of 36-year-old Lindsay Parton, now standing trial for the murder of a 3-year-old girl, Hannah Wesley, who she was babysitting. The police have been in and out for the most part for the last 40 minutes, and the jury, I imagine, Alan, at this point must be getting a little restless, watching nothing.
The main thing that jurors always complain about when I talk to them after a trial is that the whole process was too slow moving, that there were too many breaks, there was too much downtime, that there was a waste of time too often. And so I think that's, unfortunately, some of that's happening here. Some fatigue is going to set in. Jurors want to really cut to the chase. And look, it's their time. Everybody, most parties involved are getting paid really well, except for the jurors. So they can understandably get frustrated when they feel like some of their time is being wasted.
The 911 call that Lindsay Parton made to police. Alan Tuerkheimer, what do you make of that? How does that play, you think, for the jurors?
Yeah, a pretty harrowing phone call. And it sounds like somebody who really was in distress and really concerned about what just took place. And it sounds like somebody who probably doesn't have all the knowledge and wants answers. So I think that was a pretty, from her perspective, from the defense perspective, there was nothing in there that would implicate her or that would make jurors think, oh, wow, this is somebody acting. I think it seemed like a genuine phone call. Now, there's another layer to look at, given only she knows what she knows. So perhaps there's some other reason why she was like that. But I think overall, I think that seemed like a pretty normal phone call under the circumstances after somebody witnessed what she witnessed.
There was an authenticity to it. Let me ask you this. In selecting a jury for a case like this, the death of a child...
Sorry, can't hear.
In a case like this, Alan, where you're selecting a jury, the death of a child, a female defendant, what kind of jurors do you want?
Well, certainly if you're the prosecution, I guess we'll take it from the defense standpoint, because there's so much more to consider. And when you pick jurors, it's more about getting rid of ones who are negatively disposed to your case. So defense in this case, they're going to want people who are going to give a fair shake and are going to listen to the evidence and hold the prosecution to the high burden. And they're not just going to connect the dots and conclude guilt merely because a 3-year-old was tragically killed. They're going to want somebody who's going to give the defendant a fair opportunity, whether or not she takes a stand or not. But there's a lot of jurors who, when a 3-year-old tragically dies, they would have a problem not getting some kind of resolution in the case. And so that's the kind of juror that would help the defense. And the prosecution, on the other hand, they're going to want somebody who will listen to circumstantial evidence that won't need a direct smoking gun. And everybody certainly has a problem with a 3-year-old dying, but the prosecution's going to want a juror that's going to look at all the evidence, listen to the medical testimony, and connect the dots in a way that shows that she's guilty beyond a reasonable doubt.
And for the defense, are they more interested in general in a female juror or a male juror?
That's a good question. I don't think it comes down, I don't think it breaks along gender lines in this case. I think it has to do more about experiences and attitudes, maybe how people feel about the science. Some people love science and they want to get into the medical testimony. Other people think, oh, that's just something I want to steer clear of. So I think it doesn't have as much to do with that. Also, some people might have been wrongfully accused of something, most likely not anything as heinous as this case, but people who are wrongly accused might have some kind of identification psychologically with the defendant in this case. So that's something that they would have been interested in when selecting this jury.
And in general, whether they hire a jury consultant like yourself or do it on their own, it is a serious consideration, is it, as to the makeup of the jury?
Absolutely. And a lot of people say that, and I believe this to be true for most cases, the cases are won and lost at jury selection. So you have a finite number of people, and they show up in the jury pool, and then you winnow it down. You get rid of people who are too biased or they know too much about the case, but then you get into this area where certain attitudes, certain experiences, certain life beliefs, and just being these predispositions shape how jurors will interpret and assimilate evidence.
Right. Watching live coverage now of a defense lawyer, Melinda Cook-Howard, the lawyer for Lindsay Parton, trying to poke holes in the narratives created by the detectives in Butler County into the investigation of the murder of Hannah Wesche. Alan Tuerkheimer in Chicago, let me ask you, does that kind of thing resonate with the jury?
Yeah, you took the words out of my mouth. Poking holes. It's the prosecution has to get up there and give a narrative of the case and try to empower jurors to see the case their way. And then the defense, they don't have to have an alternative explanation. It helps if they do, but really their job is to poke holes and cast doubt. And what they're doing with this witness pretty effectively, I think. The defense lawyer is showing that maybe there were some stones that were left unturned. Maybe there's some other avenues, some things that could have been done differently. and we'll see how it plays out. But I think she's doing a good job of getting the jury to at least not accept word for word every single thing that this witness says. There are going to be some wondering about maybe some of the methods in the department and the sheriff's office about this case.
Do you think they're having any success in poking holes at the procedures followed by the detectives in this case?
There you go. I got it. Thanks. I think they are having some success. I think they're at least putting to rest the narrative that this was a flawless investigation from the beginning, that there are some things the jurors are going to question. I think that the defense has to be a little careful because jurors they certainly don't expect perfection. So if the jury thinks that the defense is being a little petty or maybe going into areas that humans can make mistakes, then I think that could backfire a little bit. But overall, I think she's doing a good job of poking some holes in her credibility in this investigation.
She's maintained her composure, certainly. Is she being a little too obstinate?
She can tell she's very frustrated, and I think the jury appreciates that. She's not budging, and yeah, I mean, I think if she was a little more willing to concede some things, that would probably serve her interest better. But she's definitely steadfast in her approach to this cross-examination. And a lot of jurors are thinking she's a solid investigator.
So, Alan, they're fighting over these questions. Does that mean they're getting somewhere, you think?
It's just a part of good old-fashioned law enforcement tactics. Very interesting. And it'll be interesting to see. I think the jurors are probably pretty riveted by this testimony, and jurors expect sidebars to happen. But I think once any side starts talking about lying and the potential of a tainted investigation, then the stakes get that much higher. So I don't think the jurors are too surprised by these sidebars because it's a pretty critical perspective of the case.
And when juries see them go in and talk to the judge and they can't hear what's going on, they must raise suspicions in their mind that something's wrong, right?
Absolutely. Now, jurors get sent in and out of the courtroom just for convenience. They often stay in during these sidebars, and no doubt the jurors are wondering, they see something's amiss. And the next question is, how do they resolve that in their minds? What do they think the judge and the parties are talking about? Very interesting. And we'll see how they, in the end, evaluate this witness. But yeah, for these sidebars, jurors, they expect them on some level, but they also wonder what they're talking about. But they definitely can't hear anything that they're talking about. They might try to read lips, but they won't. They're curious, but they won't know what's being said.
Alan, you've talked with jurors after trials. Do they buy this kind of thing? Are they moved by it?
I think they are. I think what's interesting is she seems, her demeanor is much different than it was earlier with the same line of questioning. She seems a little more defeated from time to time and resigned and not as confrontational. But this is certainly something jurors are going to focus on, and it's going to help shape the overall assessment of the case. It's one small piece of the puzzle, but it's certainly going to influence how they vote and how they ultimately argue for or against conviction in the deliberation room.
And you only need one juror, right?
That's correct. If you have one holdout, that's a win for the defense.
Alan Tuerkheimer, what do you make of this? Jurors like a good show, but this may be too much?
I think it's a good battle. And even though the judge says keep an open mind and be fair and impartial to the end, jurors are only human. So at this point, look, if one is strongly favor the prosecution and 10 is strongly favor the defense, not every juror is at 5. I imagine they're going in either direction, 6, 7, maybe some at 8, or 4, 3, 2. It's just impossible for them to stay neutral at this point. So their minds are starting to evolve, and as the trial goes on, their beliefs become more firmly entrenched.
Just that notion of a killer babysitter, Alan Tuerkheimer, what do you make of that?
Yeah, this is a pretty charged case, and the prosecution, that's how they're going to frame it. They're going to say, look, this is somebody, you have somebody who's a babysitter, and they're supposed to provide protection and care and love and all these good things, yet she committed this horrible crime. And it's hard for some jurors to reconcile the two, but that's how they want to frame it. And that's a narrative they're going to put forward in front of this jury. The big question is, accept.
Alan Tuerkheimer, final word in 10 seconds. What do you think is going to happen next?
Well, the key is this next series of witnesses that get trolled out there. It's just going to be a question of whether or not the jurors identify with and connect with the witnesses. And if they do, it's going to be good for that witness, and it's going to help the side that presents the witness.